I'm dying to hear what you think about the jury instructions and the closings. Professor Dershowitz, I shall start with you. Give me your quick take.
The only thing worse than the jury instructions is the failure of the defense attorneys to object to them, which precludes raising many of them on appeal. These were horrible, very, very pro-prosecution instructions. Now, I haven't read every word of them. I'm taking my cue from the media. But if the judge hasn't given the missing witness instruction, it's outrageous. Here you have.
Wait, let me interrupt you on that and say what Arthur Aidala, your friend and mine, said in our last segment. He said the judge couldn't give the missing witness instruction because he had offered to let them bring in Weisselberg in a closed door hearing, and both of them ask him questions to figure out whether they wanted him or not, and the defense declined.
Well, then it's on the defense. It's on the defense. They should not have declined. Here, the crucial conversation that occurred is witnessed only by Weisselberg and by Cohen. And in order to convict, you have to believe Cohen. And you're entitled to argue that the failure of the prosecution to give immunity to Weisselberg and to call him as a witness should create an inference that it would have been unfavorable to the defense. I don't know how the defense can fail to focus on these two crucial meetings: the phone conversation and the conversation that took place in the hotel. Without those conversations, there is any corroboration of the key point. Now, there is corroboration of the fact that money was paid. And there is corroboration of the fact that these items were listed as legal expenses and, retainers. But there's no evidence other than Cohen that Trump ordered it, directed it, knew it, other than the uncorroborated claims of Cohen. And that ought to be the central point in the defense. And so I don't know what happened in the closed sessions or anything of that kind, but for the jury to deliberate without understanding that the key witnesses have not been called and have not testified leaves an enormous gap in this case. The other thing that should have been objected to, and I don't know if Mark has ever heard of this, the idea that the defense goes first is insane.
Especially in this case.
Huh?
Especially in this case. I mean,
case. How do you defend yourself when you don't even know what the charges of the second crimes are? And it creates the impression that the defendant has a burden, either a burden of going forward or a burden of proof. So I think the New York procedure is clearly unconstitutional in violation of the Sixth and the Fifth Amendments. And I don't know, again, whether there was an objection to that. Lawyers often don't object to things that are routine, but things that are routine are often held unconstitutional. And so I'm very unhappy with the defense in this case. That doesn't mean they're going to lose. This is a New York jury. Who knows how it will go? They may win, but they won't win, I think, as a result of great lawyering.
Mm-hmm. Mark, what's your take?
That you should have had the camera on while Alan and I were talking before we came on air, because
well, tell us. We want to know.
That was even spicier. Well, first, to Alan's point, which is interesting to me, the idea of the defense going first. Normally, what happens is the person who has the burden of proof, it's a criminal case, it's the prosecution or the government. If it's a civil case, it's the plaintiff. That's why they get to go last. If you don't have something to argue against, then in essence, you have waived your burden. And to my mind, that should be a directed verdict, even though that doesn't technically exist in a criminal case. I've had cases, I don't know if Alan's ever seen it, where prosecutors got up and said, I'm going to waive my closing statement. And my response to that is, that's fine. I'm going to get up, I'm going to give my closing, but you don't get to reply because you waived. So there is that issue there. To Alan's point, I don't know, I didn't listen to Arthur, so Megyn, you can correct me. I've been entirely frustrated in this case because New York state criminal defense practitioners are loath to criticize this judge. One of the reasons I have been, I think, transparent in saying that this guy is nothing more than a prosecutor in a robe is because I don't practice in the state court there.
Right.
This judge, some of these decisions, which are being heralded on the left, I mean, if you turn on MSNBC at night, you would think that this judge is the second coming of some great judicial mind. I just don't even understand half of what he's doing in this trial. I don't understand what he did with Costello, which to me is beyond outrageous that you would take one of the defense's only substantive witnesses and basically telegraph to the jury that you're not buying a single thing that he's selling, and then create this hubbub. The idea of finding the defendant summarily in contempt for statements that were not made in your presence, which I've done a fair amount of contempt cases and politically charged cases. I don't understand any of this. I don't understand him jamming the defense after the Southern District dumped the discovery upon the defense and only giving them 30 days, and only because the prosecution conceded that they should get 30 days. I don't understand these evidentiary rulings where he's imposing or interposing his own objections. But I do understand from a practical standpoint why New York practitioners don't want to comment on him, but it's outrageous, frankly.
But the judge made one mistake. He allowed me to stay in the courtroom when he kicked out all the media and everybody else. And I stayed in the courtroom and I saw the Robert De Niro moment where this judge looked like the psycho in Taxi Driver and turned to Costello and said to him, "You talking to me? You talking to me? You looking at me? You raising your eyebrows at me? You're staring at me? I'm going to hold you in contempt. I'm going to strike your testimony." First of all, a judge has no power to strike the testimony of a witness unless the defendant did something wrong. If the witness looked at him funny, you don't get to strike the defendant's key testimony. And then to have telegraphed it in front of the jury, the judge's real self came out when he threw the media out. He's a benevolent despot when the media is there and when the jury is there. But when they're out and when only a few of us are back in the courtroom, the real Judge Marchand comes out and the bias seeps through, just reeks through everything he's doing. Now,
it's pretty amazing because the judge got so mad at Costello, he cleared the courtroom. He only let counsel stay. And Dersh was sitting in the front row, and he let him stay. He got, I think, confused that Dersh was part of the defense team or something, or just knew him as a storied lawyer and said, "You can stay," didn't kick you out. And before he knew it, you were on your show reporting about everything you'd seen and heard.
But part of me wanted him to throw me out. I would have refused to leave. I would have said, "Your Honor, the Sixth Amendment not only protects a defendant's right to a public trial, but it protects the public's right to see the trial. I'm the public. I'm not leaving unless you absolutely."
That would have been amazing. Geragos, you'd be defending him. He'd be getting bailed out. You and I would be getting him out of jail.
I would gladly defend him because Alan is absolutely right. The Sixth Amendment, you don't get to pick and choose when you want to show who you really are. And I'll say it again. I do not understand these rulings that he's making. I don't understand the evidentiary basis upon all of this. And frankly, I don't understand what's been reported as the jury instructions. It's the whole thing to me.
Let me ask you a question about that. Okay, let me ask you something, Geragos, on that. Because one of the controversial things, among many, the judge let in was the fact that Michael Cohen pleaded guilty to a federal election law violation. He was already going away on his taxi medallion scheme and his tax violations. And then the feds were like, "Oh, and also, how about this federal election law violation?" And by that point, Cohen was like, "Fine, okay, I'll plead guilty to that too." And the judge allowed that in. And let me finish. And he also allowed in that David Pecker of AMI struck a cooperation agreement with the feds around these same federal election law alleged violations. Now, he let the government bring that stuff out on their own witnesses. Normally, that would be like a Geragos or an Alan Dershowitz cross moment, like, "You pleaded guilty to this bad thing, didn't you?" But But you wouldn't do that here because Trump doesn't want any of that in front of the jury because it makes it sound like they're all guilty of the thing they cooperated with Trump on. Go ahead, Mark.
Well, then he compounded it because they put forth a witness. If you look at what Trump keeps posting, he keeps posting, I had a witness. I wanted a witness to opine on these issues.
Brad
and
Smith.
And he excluded the witness. To me, there's been a lot of things, I don't disagree with Alan that there's been a lot of waiver here, inexplicably, but maybe, I'm always hesitant to criticize the trial lawyer in the middle of the fray. But I will tell you that the idea that you allow in all of this stuff with the idea and then allow in closing, which happened yesterday, to talk about federal election crime, but knowing at that point that the judge has excluded their proffered witness who would have opined that there was no election law violation.
Right. And the judge today, Alan, I'll give it to you in 1 second, but the judge today, Alan, said he tried to fix it with a limiting instruction to the jury saying, I let all that stuff come in about Michael Cohen's guilty plea to federal election law violations and the cooperation agreement with David Pecker, not to prove that they're actually guilty or that Trump's guilty of anything, but because it goes to their credibility. But it's like, okay, it was the prosecution's own witness. The prosecution brought it up. It was all used against Trump. And that bell had been rung. The jury had heard that two of the star witnesses had already basically pleaded guilty or admitted to the crime. Go ahead, Mark, and then I'll go to Alan.
He let the prosecutor argue it. He excoriated
over and over
for saying liberty. I mean, by the way, I haven't ever done a criminal or civil trial where I haven't talked to the jury about the difference between fighting over money and fighting over liberty. Since when is that verboten that you're going to get excoriated by a judge by saying send somebody to jail? It's a colloquialism. You're not telling them that they're going to do the sentencing, which is verboten. But the fact that he allowed the prosecutor to argue these things and to argue them, that's why he gave the limiting instruction, because he realized, in my mind, that was reversible.
They argued it a lot in closing yesterday. The prosecution did. It was outrageous. They compounded the injury. Go ahead, Alan.
Remember that Cohen not only pleaded guilty himself, but he basically said, hearsay, and so Trump is guilty too. He's my co-conspirator. And the federal government, complicit with the state in this case, compelled Cohen to make a kind of hearsay accusation of Trump that could then be used against Trump. And that's why it was so imperative that the expert witness be allowed to testify, no, there was no violation of federal election law here. First of all, the idea that somehow voters would be defrauded because they all believe that Donald Trump was this virgin, this man who's never had any sexual misconduct in his life. And then the prosecution arguing essentially that he would never have been elected if the material about Stormy Daniels had come out. First of all, voters of New York voted against him overwhelmingly. Second of all, everybody knew that Trump was a player, and whether or not it included Stormy Daniels is totally irrelevant.
Let me tell you a story about a guy named Leo Grillo. Leo was on a road trip and came across a Doberman. This dog was severely underweight and clearly in trouble. Leo rescued the dog and named him Delta. But sadly, Delta was just one of many animals that needed help, and this inspired Leo to start Delta Rescue, the largest no-kill, care-for-life animal sanctuary in the world. They've rescued thousands of dogs, cats, and horses from the wilderness, and they provide their animals with shelter, love, safety, a home. April marks 45 years since Leo rescued Delta. Delta Rescue relies solely on contributions. If you want caring for these animals to be part of your legacy, speak with your estate planner because there are tax benefits here too. You can grow your estate while letting your love for animals live well into the future. Check out the estate planning tab on their website to learn more and speak with your advisor. We call dog a man's best friend for a reason. You can help those who need it most. Visit deltarescue.org today to learn more. That's deltarescue.org. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.